Today we are going to start this topic, written statement, and along with written statement, we'll further discuss this concept of set-off and counterclaim. And these are all important for your examination. As we have already discussed till this point, that when a plaint is filed in the court issues summons. And as we have read yesterday, that summons are issued for different purposes. But primary purpose of issuing summons is generally that the other party will file his reply to the plaintiff's plaint. Now, this reply is basically filed by the other party, that is called the defendant. So, defendant will file his defense in this written statement. Now, in this context, there will be various questions which will come up in your mind and which will be relevant for discussion also. That what is this written statement all about? When it will be filed? What will be the time to file this WS? In brief, it is called WS. What is the maximum time period to file this WS? If defendant has not filed a WS, what will be its consequence? Why it is necessary to file WS? What is the object? What is the object of filing this WS? And if defendant does not file, what will be the consequence of this? Then there will be further question that what is this limitation for filing WS? What is this limitation for filing set-off? What is this limitation for filing counterclaim? What is the limitation period for all of them? Now, when we file set-off and counterclaim, what is the consequence of that? What is the difference between the two? Is there any consequence, or is there any concept of equitable set-off as well? What are the rules relating to that? So let us discuss all these questions one by one. We'll discuss them one by one, not an issue at all. Let us begin with this. What is this a written statement basically? Let us look into order 8 and we'll see further the provisions here and there. Now, you have read already order 6. Order 6 talks of pleading. There are many connected provisions which we are required to relook. As we saw in plaint, we have seen in pleading order 6 rule 1, pleading is plaint for plaintiff and written statement for defendant. So all the rules which you learnt in drafting of plaint will be repeated here in drafting of written statement. All those rules will be applicable in drafting of WS as well. If you do not draft WS well, then your case may be jeopardized. Your defense may not be taken well by the court. Many points which are not raised in WS may not be raised later on. Defense cannot produce evidence beyond its pleadings. So it is necessary to bring all the relevant points in WS. So this topic in that sense is very important. What is WS? WS is basically a kind of reply to the plaintiff's plaint, where defendant will either admit the claim or reject the claim or put forward his own defense. So what you do in written statement? Either you admit the claim or you reject the claim, or you, that is, deny the claim, or you bring defense from your side, or you can claim set off, or you can claim counterclaim. We'll be talking about this set off and counterclaim little later. But let us begin with this WS. So WS is basically an answer, a reply by the defendant to the plaintiff's plaint. See, this WS is necessary to be filed. If you do not file the WS, then how the court will decide the matter? Because if you see Order 14, Order 14 talks of issue. When there is no issue, what kind of judgment the court will give? So there has to be some issue for decision of the court. There has to be some issue for the decision of court. So it says issues arise when a material proposition of fact or law, Order 14 Rule 1, issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. So if something is pleaded by plaintiff and it is not denied by defendant, where is the issue? There is no issue. So how the court will decide the matter? So this is why it is necessary for defendant to file WS, but we cannot compel defendant to file WS always. Even if he does not file the WS, court will decide the matter. But primarily, if there is no defense from the side of defendant, then there is no issue, so there will be no decision. So unless defense is there or some kind of contradiction is there, what issue? Issue will arise when there are two parties which are at variance. I say that I have paid you money, you say that you have not paid me money. Then there is issue whether the money has been paid or not. Then only the court can decide whether there is payment of money from one to the other and there is debt which is recoverable and the debt has to be paid now, so it will be recovered. But if there is no denial of this fact, there is no contradiction of this fact, then the court has nothing to say. Money has been paid and you do not deny, then it is clear that the money has been paid and the court will say similarly. So defendant has to raise or defendant has to file WS, but if he does not file WS, then it is not necessary that the court will pass the decree and order. Court will even then ask the plaintiff to prove its point. It is the discretion of court to be convinced. If court is not convinced, obviously court will ask the plaintiff that you please prove these points. So court can proceed even if there is no issue. Even if there is no issue, court can proceed. And court can require plaintiff to prove certain points. Because court has to be convinced. Even if defense does not say anything, defendant does not say anything. Now court has a duty to see that case is properly considered. Properly considered. It is the duty of court. Court has various duties. Like, see, I tell you, even in Limitation Act, suppose a suit is barred by limitation and it is not said by the defendant that the plaintiff suit is barred by limitation, even then it is duty of court to see whether it is barred by limitation or not. So section 3 is there. It says, subject to the provisions contained in section 4 to 24, every suit instituted, appeal preferred and application made after the prescribed period, limitation period is there, shall be dismissed. So it is the duty of court to dismiss it, although limitation has not been set up as a defense. So even if defendant does not say anything about this bar of limitation, even then it is duty of court to look into the matter and to dismiss the suit because it is barred by limitation. It is barred by limitation. So it is the duty of court in various situations to look into the matter. And court can ask the plaintiff to prove the point if it thinks that there is an averment in the plaintiff's plaint which is not properly now acceptable, prima facie acceptable. So court can ask the plaintiff to prove the point. That is the discretion or authority of the court, even if defendant does not say anything. But pleading from both sides is necessary because see, there is basic rule of law that there should be hearing from both parties or hearing of both parties, audi ultram partem. Principle of natural justice will apply. It is expected of defendant that he should file WS, but if he does not file WS, he is harming his own case. Now, in filing of WS, he has to take further care. We will see this in Order 8. Order 8 has various rules where these things have been discussed. But before you go into Order 8, when you draft WS, then you are required to revisit Order 6 because WS is also a kind of pleading for defendant. That is what you have read in case of plaint also, if you remember correctly. You read Order 6 in plaint also. So Order 6 has certain rules which you must revisit. You must revisit. There are various rules. Now, like Rule 2 says, pleading to state material facts and not evidence. So pleading should contain only material facts. No, only a statement in concise form of material facts on which the party pleading relies for his claim or a defense. So claim for plaintiff and defense for defendant, but not the evidence which they are to be proved. Now, by which they are to be proved. Defense will be brought later on, obviously. Every pleading shall be divided into paragraphs numbered consecutively so far as convenient, contained in separate paragraph. Order 6, Rule 2, Sub-Rule 2. Sub-Rule 3, dates, sums and numbers shall be expressed in pleading in figures as well as in words. So that is what is commonsensical. You have already read this. Rule 4 says particulars to be given when necessary. In all cases in which party pleading relies on any misrepresentation. I say, now you say that there is a contract between you and me. But I say that no, contract is caused by misrepresentation or fraud or no, undue influence. Then I will have to plead this specifically. That the contract is there. Contract is there as averred by the plaintiff, but it has been caused by fraud, misrepresentation, or undue influence, whatever is there. Now, so it says in which particulars may be necessary beyond such as are exemplified in forms aforesaid, particulars shall be stated in the pleading. So, if you want to argue all these points as defendant or as plaintiff, you will have to bring it very clearly in your pleadings. Rule 4. Rule 6, condition precedent. Any condition precedent, the performance or occurrence of which is intended to be contested shall be distinctly specified in his pleading by the plaintiff or defendant as the case may be. And an averment of the performance or occurrence of all conditions precedent necessary for the case of plaintiff or defendant shall be implied in his pleading. So, condition precedent, the performance or occurrence of which is intended to be contested. Like now, there may be some kind of condition precedent in certain cases. Like I say that unless and until you deposit security money, I cannot supply you the goods for sale. And you do not provide the security money. So this condition precedent is required to be pleaded in case of that situation where that contract is alleged to be entered into and non-performance is alleged. So, in that case, this condition precedent is required to be brought forth in the pleading. That see, this was the condition precedent which has not been complied with. He was required to deposit the money, security money, which he did not. And as he did not deposit the security money, and that is why I did not give him the supply of goods for further sale. So these are commonsensical general points. You will understand it even better when you see this in practical sense, but these things have to be read also. Denial of contract, Rule 7 and Rule 8. Rule 7 is departure. No pleading shall except by way of amendment raise any new ground of claim or contain any allegation of fact inconsistent. Now, if you make inconsistent pleas, obviously you will be confusing the court and you will be harming your case yourself. So you have to bring forth your claim or a defense. Now, in such a way that there should be no contradiction or inconsistency between two things which you have said. In many cases, inconsistencies may jeopardize your case altogether. So be careful about that fact. Be careful about that fact. Inconsistencies should not be pleaded. That is what is the caution. Denial of contract. Where a contract is alleged in any pleading, a bare denial of the same by opposite party shall be construed only as a denial in fact of the express contract alleged or of the matters of fact from which the same may be implied, and not as a denial of legality or sufficiency in law of such contract. Where a contract is alleged in any pleading, a bare denial of the same by opposite party shall be construed only as a denial in fact of express contract alleged or of the matter of fact from which the same may be implied, and not as a denial of legality or sufficiency. So if you deny the contract, it means that you are denying the fact of contract and not denying its legality or sufficiency. That is not denied. I say that there is a contract and you say that there is no contract. So what are you doing? You are saying that there is no contract. So you are questioning the existence of contract, not its legality or sufficiency. Is this clear? So Rule 2, Rule 4, Rule 6, Rule 7, Rule 8 is relevant to be seen. Presumptions of law. Presumptions of law are not required to be pleaded because it is presumption of law. Like there in Evidence Act, you find many presumptions. Shall presume, may presume, conclusive proof. So these are presumptions which are given in law. So you are not required to plead them, or you are not required to tell them. Now, knowledge of law is everywhere there. Every court has knowledge of law. Neither party need in any pleading allege any matter of fact which the law presumes in his favor. Like there is a presumption in Evidence Act, in any provision. In any provision. So that presumption will be there. That presumption will be there. It is not required to be told to the court because it is there already in the law. May presume, shall presume, conclusive proof. There are three kinds of presumptions in your Evidence Act. You may find it better in that section 111, I hope, or there are various other provisions also. Section 114 is there. There are various provisions in Evidence Act which talks of the presumptions. No? There are various provisions of presumptions. Presumption as to Dory death, 113B. The presumptions are there. 114 is very relevant. Court may presume existence of certain facts. So, like you are in possession of a stolen good, so soon after the theft, so it will be presumed that either you are the thief or you have received the stolen goods. 114A, clause A. So nothing great in this. It's very simple that the presumption which are there in law, in the act, is not required to be pleaded. It is presumed. It is accepted. It is acceptable. Is this all right? Presumption is acceptable. So all these rules are relevant in understanding of now this written statement as well. So you please look into Rule 2, Rule 4, Rule 6, Rule 7, Rule 8, now, and then Rule 13 also. So these are connected provisions in writing of written statement as well. No material facts, not defense. No inconsistency in your pleading. So I hope you understand this preliminary thing that written statement is required for proper decision in the case. Then only issues can be framed as per Order 14 because there are admission of one, there is a claim of one and denied by another. So then only the issue will arise. It can be issue of law or issue of fact. So defense has to bring his written statement, then only court can say that or court can frame issue. Otherwise it's difficult. But I said at the same point of time that even if defendant has not filed his WS, it is not the law that the court will pass the decree immediately or court will pass the order immediately. It is not the law. Court may ask the plaintiff to prove its averments in its plaint, and court may require evidence to be convinced because court has to do justice in that case. Court cannot accept everything on the face of it. Court may require evidence to be brought by the plaintiff. So that is all in the beginning. So you understand that written statement means a statement of defendant which he files as a reply to plaintiff's claim. Is this clear? Now, the second question which I raised is, what is the time for filing of this WS? What is the time? What is the time of filing of WS? Time for filing. Now you can frame a question. What is the maximum time to file a written statement? Let us read for this answer Order 8, Rule 1. It says defendant shall within 30 days from the date of service of summons on him present a written statement of his defense. Substituted by Act 22 of 2002, Section 9 for the Rule 1. So what it says? It says that the defendant shall within 30 days from the date of service of summons on him. So within 30 days from date of service of 30 days from the date of service of summons, 30 days. Provided that where the defendant fails to file WS within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summons. So it prescribes the maximum also. "90 days from date of service of summons." This is the maximum. "30 days, maximum is 90 days. Now the question arises, can we go beyond this 90 days? And in case of commercial disputes, it is written, where the defendant fails to file the WS within the said period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reason to be recorded in writing, and on payment of such cost as the court deems fit, but which shall not be later than 120 days from the date of service of summons. On expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file WS, and the court shall not allow the written statement to be taken on the record. So in commercial disputes, 120 days is the maximum time. Court cannot go beyond this. But you do not find similar language in case of 90 days. Can you see this? In this it is written, court shall not allow, and defendant shall forfeit the right to file WS. You do not find similar words written in Rule 1 proviso. We do not find similar rule written in Rule 1 proviso. Can you see this? We have not written this in Rule 1 proviso. So in commercial disputes, maximum time is 120 days from date of service of summons. 120 days from date of service of summons. 120 days. No extension by court. Defendant has no right to file WS after 120. This is the maximum in case of commercial dispute. This is maximum in case of commercial dispute. But proviso 1 does not say anything like this. Order 8, rule 1, proviso doesn't say anything. So now I am raising a question in order 8, rule 1, proviso. That question is whether maximum provided by proviso to rule 1 of order 8 is the maximum limit, or can it be extended in any case? This is the question. Can we go beyond this 90 days? That is the question. Can we go beyond 90 days? That is the question. Can we go beyond 90 days? That is the question. Now, answering this question, the courts have said in various cases, and I will read some para for you. Supreme Court said in various cases, especially in Salem Bar Advocate Association versus Union of India. Salem Bar Advocate Association versus Union of India. No. Just a minute, hold on. वो कहाँ डाला हमने केस? डेस्कटॉप पे तो यही वाला है. See order 8 rule 1 here. तो मैंने केस कहा, वो ये नहीं है. चलो, यस, काम कर जाएगा. यस यस. There is this para 20 and I just show you, don't worry. I just show you this. Para 20 says the use of word shall I want you to read this, it's very important. The use of word shall in Shall in order 8 rule 1 by itself is not conclusive to determine whether the provision is mandatory or directory. This is one question, whether the provision is mandatory or directory. Because see, if you see this order 8 rule 1, it says defendant shall within 30 days. And then it says provided that where defendant fails to file WS within the said period of, he shall be allowed to file the same on such other date as may be specified by the court for reason to be recorded, but which shall not be later than 90 days. Shall not be. So this is what is being said. The shall in order 8 rule 1 by itself is not conclusive to determine whether the provision is mandatory or directive. We have to ascertain the object which is required to be served and its design and context. The use of word shall is ordinarily indicative of mandatory nature of provision, but having regard to the context in which it is used or having regard to the intention of legislature, the same can be considered as directory. The rule in question has to advance the cause of justice and not to defeat it. The rules of procedure are made to advance the cause of justice and not to defeat it. Construction of the rule or procedure which promotes justice and prevents miscarriage has to be preferred. We will adopt such construction which promotes justice and prevents miscarriage. The rules of procedure are handmaid of justice and not its mistress. In this present context, the strict interpretation would defeat justice. See the point. The strict interpretation would defeat justice. So this should not be done. This should not be done. Then it says further, you see carefully, in construing this provision, support can be had from Order 8 Rule 10, which provides that where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court shall pronounce judgment against him or make such other order in relation to the suit as it thinks fit. On failure to file WS, the court has been given discretion either to pronounce judgment against defendant or make such other order in relation to the suit as it thinks fit. I have already told you it can ask the plaintiff to prove the things. In the context of the provision, despite use of the word shall, the court has been given the discretion to pronounce or not to pronounce the judgment against defendant. Court can pronounce judgment, court may not pronounce judgment, even if written statement is not filed, and instead pass such order as it may think fit in relation to the suit. Is this clear? In construing the provision of Order 8, Rule 1 and 10, the doctrine of harmonious construction is required to be applied. Doctrine of harmonious construction. The fact would be that under Rule 10 of Order 8, the court in its discretion would have power to allow the defendant to file WS even after expiry of period of 90 days. The court can have power to now allow this WS to be filed even beyond 90 days. Even beyond 90 days. Even beyond 90 days. So the two things which I can make out, that the Order 8 Rule 1, the time period is not mandatory, it is directory. Even if the word shall is used there, it is directory provision. And the second, court can allow him to file WS even after 90 days if it thinks fit to do justice in a particular case. No? To do justice in a particular case. You be careful about this. So if justice, it says further, there is no restriction in Order 8 Rule 10 that after expiry of 90 days further time cannot be granted. Court has wide power to make such order. Court has wide power to make such order in relation to suit it thinks fit. Clearly, provision of Order 8 Rule 1 providing upper limit of 90 days to file WS is directory. Having said so, this is very, very important. Law is not mathematics. Court ने कह दिया You can go beyond the 90 days. So I can say that, yes, I will go beyond the 90 days. I will file WS after 100 days. No, no, no. We wish to make it clear that the order extending time to file WS cannot be made in routine. It is exceptional case. The time can be extended only in exceptionally hard cases. Exceptionally hard cases, not in all cases. While extending time, it has to be borne in mind that the legislature has fixed the upper limit. The discretion of the court to extend the time shall not be so frequently and routinely exercised so as to nullify the period fixed by Order 8, Rule 1. This is not allowed. This is not allowed. This is a very important observation. So, third point I want to add, that see, there is power with the court. There is power with the court to file WS or to accept WS even after expiry of 90 days. Even after expiry of 90 days. No? Even after 90 days. There is disability on defendant in this case. There is disability on defendant, not on court. Disability on defendant, not on court. So there is disability on defendant and not on court. So defendant is now disabled. He cannot assert it as a matter of right that I can file suit after 90 days. No, no. Now it is discretion of the court. It is discretion of court. It is discretion of court after 90 days. It is discretion of court after 90 days. It is discretion of court after 90 days. Discretion of court after 90 days. It is discretion of court after 90 days. Is this clear? So you are required to read this again and again. This is very simple observation. I may read it again for you. If you have any concern, any question, any doubt in your mind, it starts from here, para 20. Court has raised a question earlier. No? Para 17 also says. Para 16 says, it has been common practice for the parties to take long adjournments for filing WS. The legislature, with a view to curb this practice and to avoid unnecessary delay and adjournment, has provided for maximum period within which the WS is required to be filed. The mandatory or directory nature of Order 8, Rule 1 shall have to be determined by having regard to the object sought to be achieved. It is thus necessary to find the intention of the legislature, the consequence which may follow, and whether the same were intended by legislature have also to be kept in view. So, taking adjournments again and again, which has created huge delay now in our system, which has created huge delay in our system, that has to be discouraged. That has to be discouraged. The question is whether court has any power or jurisdiction to extend the period beyond 90 days. The maximum period of 90 days to file WS has been provided, but the consequence on failure to file WS within the said period have not been provided for in Order 8, Rule 1. The point for consideration is whether the provision providing for maximum of 90 days is mandatory, and therefore the court is altogether powerless to extend the time. So answer is that court is not powerless to extend the time. Court has discretion, court has authority, court has power to allow this WS to be filed even after expiry of 90 days. But there should be exceptional reason for this. Now, suppose somebody says that I was on deathbed for last 2-3 months. So can we expect him to file WS when he was lying on deathbed? Now he has recovered after 4 months. Now he comes after 120 days to file WS due to this reason. Will you disallow him to do it? Or somebody says that I met with an accident, or I uh, faced this corona crisis where I was subjected to this coronavirus, where I was lying on the bed for last 6 months. So will you expect him to file WS? No. Justice has to be done. And what is the concern of justice? What is the concern of this provision? That there should be no undue delay or adjournments. The case should be decided as early as possible. But where there is exceptionally hard region, whereby you cannot comply with the rule of procedure, then it is not mandatory to be followed. Procedure is handmaid to justice. Procedure is mistress, not the master. It is rule of procedure. It is rule of procedure, and that is what has been clarified time and again. So, even in this case, Sambhaji and others versus Gangabai and others, 2008-17 SCC. 2008-17 SCC. Two 2008-17 SCC, what it says? 'So in this case also the court said that the provision is procedural and not mandatory. It does not debar the court. It does not deprive the court of its it does not deprive the court of its power. It does not deprive the court of its power. Rather, it bars the defendant to claim it as a matter of right. Now, there are various other decisions where this point has been reiterated time and again. So, I sum up that you are required to file WS within 30 days. If you are not able to file WS within 30 days, then you file it within 90 days. But if there are exceptional reasons for not filing WS within 90 days, then you can file it even after 90 days. But in that case, it is not your discretion, it is court's discretion. It is court's discretion. It is court's discretion. So, are you clear on this point? Now, they have referred Order 8, Rule 1, Rule 9, Rule 10 also. So, let us see this Order 8, Rule 1, Rule 10 and Rule 9 as well, what is written there. Order 8, Rule 1 you have read, defendant shall within 30 days, from where 30 days will be counted from the date of service of summons. And then maximum has been provided 90 days, in commercial disputes 120 days. Can we go beyond 90 days? I have explained through Salem Bar Advocate Association. Salem 2 case is this. Salem Bar has 2 cases of 2003 and 2005. So be careful, it is Salem 2 where this decision was given, and the court has clarified that court has discretion even after 90 days to allow WS to be filed, but there should be exceptional reason. It should not be made a matter of routine, because our purpose is to avoid adjournments and to now avoid delay in disposal of the cases. We want expeditious disposal of the cases. We want to expedite the process. So this is rule 1. Now let us see this Rule 9 and Rule 10, which is referred in this decision also. Rule 9 says no pleading subsequent to WS of a defendant other than by way of defense or set off or counterclaim shall be presented, except by the leave of court and upon such term as the court thinks fit, but court may at any time require a WS or additional WS from any of the parties and fix a time of not more than 30 days for presenting the same. So there is authority with the court that the court may at any time require a WS or additional WS and may fix a 30 days time at any time. At any time court may allow subsequent pleading. The court may allow this to be filed even at any time. Then Rule 10 says, where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted. Now, court has granted you time of filing this WS, now even after 90 days, and you do not file it. As the case may be, the court shall pronounce a judgment, and the court has authority to pronounce judgment against you, and make such order in relation to the suit, or make such order in relation to the suit as it thinks fit, or make such order in relation to the suit as it thinks fit. And on the pronouncement of such judgment, a decree shall be drawn up. And on the pronouncement of such judgment, a decree shall be drawn up. So it says, where any party from whom a written statement is required, if WS required to be filed within permitted time and it is not done within that time, then the court shall pronounce judgment again and again. Court shall pronounce judgment, but we have given again leverage to the court, or may make such order. As it thinks fit. May make such order as it thinks fit. The court has again and again so this order 8, Rule 1, Rule 9, Rule 10 very clearly say, if you read them together, then it gives clear hint that this time period of 90 days is not mandatory. It is directory. But we want to add it, we want to clarify it that the period of 90 days should be generally adhered to. If there are exceptional cases, we may allow you to file WS even beyond 90 days. This provision is directory, not mandatory. Additional pleading can also be allowed to be filed, but if you do not file within the allotted time, then you will have to suffer. Court cannot wait for you indefinitely. Court अनंत काल तक आपके लिए नहीं रुकी रहेगी. So you will have to understand that you have been granted time to avail the right. If you do not avail the right even thereafter, it is not fault of the court, it is your fault. So you are now disabled. Kailash versus Nanku is also there, where the court said that this provision is directory and permissive and not mandatory or imperative. This provision is directory and permissive and not mandatory or imperative. So I hope you understand this, no? Is this clear? You tell me, yes or no, is this clear? This is what is relevant in written statement, my dear friend. Order 8, Rule 1, duty of defendant to produce documents upon which relief is claimed or relied upon. If where defendant is Defendant bases his defense upon a document and relies upon any document in his possession or power in support of his defense or claim for set-off or counterclaim. He shall enter such document in a list and shall produce it in court when the written statement is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the written statement. Where any such document is not in possession or power of the defendant, he shall wherever possible state in whose possession or power it is. A document which ought to be produced in court, very important this, Rule 1A, Sub-Rule 3, by the defendant and but is not produced, shall not without the leave of court be received in evidence on his behalf at the hearing of the suit. So, if you do not file the document on which you are going to rely, then you cannot bring this letter on. Now it is again the discretion of court. See, wherever you fail in your duty, then you cannot enjoy. Now, if you miss the bus, if you fail in your duty, if you are negligent, law supports vigilance, not indolence. Law supports vigilance, not indolence. So, if you are not vigilant, court cannot help it. So, that is what is being said in Order 8, Rule 1A, where defendant bases his defense upon a document. So, if you are basing your defense on a document, you bring the document. Your claim of set-off or counterclaim, whatever it is, shall enter such document in a list. You give the list and there you mention this document, and shall produce it in court when the written statement is presented by him, and shall at the same time deliver the document and a copy thereof to be filed within the WS. To be filed within the WS. So, if now duty of defendant to produce documents. Now, the plaintiff has also got duty in Order 7, Rule 14, if you remember correctly. Order 17, Rule 14. Then it says, nothing in this rule shall apply to document produced for cross-examination of plaintiff's witness or handed over to witness merely to refresh his memory. So, that is allowed. See, you might be aware that in defense, in evidence law, you can use certain documents to refresh your memory. I think 159 or 160 is on that point in your Evidence Act. So, you can bring document to refresh your memory. So, that is not prohibited. Even if you have not filed this document, you have not submitted this document with your WS, you can bring the document to refresh your memory. That limited use is allowed. What I said? What is your duty if you are going to use document in evidence, or you are going to rely on evidence, rely on document in your evidence, then you should produce that document in advance, as per Order 8, Rule 1A. But if you do not produce that document before, then it is discretion of court to allow or not to allow. This is written in Section 164 of Indian Evidence Act. Order 8, Rule 1A, duty of defendant to produce document on which he relies. To produce document on which he relies. Duty of defendant to produce document on which he relies. That's good. But if he does not produce, with WS, if he does not produce document with WS, then later on it is dependent on court's permission. Court's permission or leave. If court permits, then you can produce the document, otherwise you cannot. This is also written in Section 164 of Indian Evidence Act. Is this clear? But this embargo which is imposed on you, that you cannot produce it now unless and until court permits you, this embargo does not apply. This embargo does not apply this embargo does not apply. This embargo does not apply to documents. This embargo does not apply to documents produced for, number one, produced for cross-examination. This embargo does not apply to produce for cross-examination of plaintiff's witness. So if defendant wants to cross plaintiff's witness for that purpose, he can bring document. And second, for rephrasing memory of witness. So if witness memory is to be refreshed, then that document, witness can use that. This is written in, I hope, 159 and 160 of Indian Evidence Act. I have brought Indian Evidence Act. You can also see this. Refreshing memory. A witness may, while under examination, refresh his memory by referring to any writing made by himself. So 159. And 160, testimony of facts stated in document mentioned in section 159. So a witness may also testify to facts mentioned in any such document as is mentioned in section 159, although he has no specific recollection, if he is sure that the facts were correctly recorded in the document. He remember that the document correctly recorded it, but he doesn't remember that what exactly he recorded. So you can use this for refreshing memory of witness, section 159, section 160 of Indian Evidence Act. Is this clear? And a defendant can bring this Is this clear, my dear friend? This is Evidence Act. But it is an important point to be taken care of, that if you do not produce document in advance, you are going to suffer. Now you cannot use it in evidence. You can use it for cross-examination and you can use it for refreshing memory. So there is limited use. There you can use in limited way. You cannot use it in evidence to support your case or claim. You can use it for cross-examination, one purpose, or you can use it for refreshing memory of witness. Only for these two limited purpose, only for these two purpose, the document can be used. The documents not produced with the WS, document not produced, the documents not produced with WS can be used only for these two purposes. Court can allow, court can permit, that's a different matter altogether. Is this clear? Order 8, Rule 1A, Sub-Rule 4. Then it says, new facts must be specifically pleaded. Defendant must raise by his pleading all the matters which show that the suit not to be maintainable or that the transaction is either void or voidable in point of law, and all such ground of defense as is, if not raised, would be likely to take the opposite party by surprise or would raise issues of fact not arising out of the plan, as for instance, fraud, limitation, release. So you cannot, uh, you must raise the question that the suit is not maintainable, or the transaction is either void or voidable in point of law, and all such ground of defense, as if not raised, would be likely to take the opposite party. Now, it says new facts must be specific, defendant must raise by his pleading. It is your duty to raise all this in now, in advance, in beginning, that suit is not maintainable, or the transaction is either void or voidable, or all grounds of defense. And if not raised earlier, it would be likely to take the opposite party by surprise or would raise issue of fact not arising out of plan, as for instance, fraud, limitation, release, payment, performance, or fact showing illegality. So you cannot do it now. You should raise it all in advance. So if you want to bring these facts, it must be specifically pleaded. And you cannot bring anything later on, and you cannot raise these points later on. Now, suppose you did not raise it beforehand, as it is being said in Order 8, Rule 2, and you bring it later on. Now, plaintiff has given his evidence, and now defendant's turn has come, and defendant is giving his evidence. And now defendant brings these points. So, plaintiff will be taken by surprise. So, is it justified? Is it natural? Is it genuine? And is it going to help in expeditious disposal of the cases? Speedy disposal of the cases? Not at all. So that is why we are saying that you be cautious, and that in beginning itself you bring all these matters before the court in advance. You please tell the court everything in advance, that this is the fact, and you bring all supporting things in advance itself. Why you are bringing it now? Suit was not maintainable, so it should be told beforehand. Transaction is void or voidable, it should be told beforehand. Illegality or other ground, why did you not raise it earlier? It shall not be sufficient for a defendant, Rule 3, in his WS to deny generally the grounds alleged by plaintiff, but defendant must deal specifically with each allegation. Contract is there, it is not there. It is not there. Contract is there, but it is void contract, or it is void agreement. So you bring it beforehand and you plead it specifically. See, these are very important for clarity in the case also. This is very much required, that we should be careful about these things well in advance. Well in advance. Now, if there is a contention that I paid some money to you, so you specifically deny that fact, that I did not pay any money on such and such date, and even on other date. I say that I have given you 5 lakh rupees on October 1, 2015. So you specifically deny that you have not given me 5 lakhs rupees or any other sum of money, either on this date or on any other date. I do not owe any money to you. So you specifically deny that you have not given me 5 lakhs or any other sum of money, either on October 2015 or on any other date. Specific denial should be there. When a defendant denies an allegation of fact in plaint, he must not do it evasively, but answer the point of substance. Thus, if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any other part, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. You have to be very clear, cogent, specific in your denial. And if you do not deny it, then it will be considered admitted, except regarding the person of disability, Rule 5. Provided that court may in its discretion require any fact so admitted to be proved otherwise by such admission. So admission is also a proof. You know this. Evidence Act, if you have read, admission is itself a proof. But even then the court may ask the other party to prove it by other evidence, even if there is admission. So suppose you say that there is a contract and I admit that there is a contract, but court can ask the other party to prove the contract. Rule 5. These are commonsensical rules. So you read them carefully. This will help you in writing written a statement in a better way. Sambhaji and others. There are various judgment here and there which may be relevant. I read various judgment, but I will not recommend you to read all of them. Otherwise, it may be, little bit cumbersome. Uh, hmm, may be cumbersome for you to do this. See, you just read this order 8 rule 1A. There is order 7 rule 14 also. Order 7 rule 14 is production of document on which plaintiff sues or relies. So I read it here now. Where a plaintiff, order 7 rule 14 similar rule as order 8 rule 1A. Where a plaintiff sues upon a document, relies upon document in support of his claim, he shall enter such document in a list. That is his duty of plaintiff. And shall produce it in court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. So he has to produce the copy and the document and the copy also. Where any such document is not in possession, then he will communicate to the court if it is known to him that in whose possession it is. A document which ought to be produced, sub rule 3, in court by plaintiff where the plaint is presented or to be entered in list or next to the plaint, but it is not produced, shall not, there is embargo, without the leave of court be received in evidence on his behalf at the hearing of the suit. I said section 164 of Indian Evidence Act. Now it says, nothing in this rule shall apply to a document produced for cross-examination of defendant's witness. This is wrongly written plaintiff's witness. This is error in drafting of CPC. This is error in drafting of CPC for which I am not responsible. For which I am not responsible. Legislature which is responsible for this. So you please correct this. It is order 7 rule 14. It is defendant's witness, not plaintiff's witness. It is defendant's witness. Because plaintiff will cross-examine defendant's witness. We are talking of plaintiff right now. Plaintiff files plaint in order 7. So it is defendant's witness, not plaintiff. Order 7, rule 14, sub-rule 4. Order 7, rule 14, sub-rule 4, it is defendant's witness, not plaintiff's witness. This error was pointed out when it was enacted, and it was requested to Parliament to get it corrected, but Parliament did not do it. So Supreme Court in Salem 2, in para 34 in particular, Supreme Court in Salem 2 in para 34 in particular, Supreme Court in Salem 2, para 34 in particular. Now, if you want to write the citation, it is 2005 judgment of Salem. This is AIR 2005, Supreme Court 335. AIR 2005, Supreme Court 3353. So now in this case, the court said, Supreme Court said, that until it is corrected, by Parliament, it will be read, as defendant's witness. Order 7, Rule 14, Sub-Rule 4. Order 7, Rule 14, Sub-Rule 4. Is this clear? It is defendant's witness. It is basically an error in drafting. There are various provisions where drafting has not been up to the mark. It can happen with any human system. If you expect everything to be ideal, then it is not possible. Human being cannot be ideal. There has to be some kind of imperfection. There will be some imperfection here and there. So this is about this WS. I think we have covered substantial points. Oh, I also commented on this point that if defendant does not file WS, it does not mean that the court can pass decree in favor of plaintiff. There is no law like this. There is no law like this. Even then, the court may ask the plaintiff to prove its point. If defendant has defaulted, it does not mean the plaintiff will have all the way. No. No. Court may ask him to prove his point. Court may ask him to bring evidence. So this is all on written statement. Now, in the second session, we'll discuss about set-off and counterclaim. So till then, let us have 5–10 minutes break, and then we'll begin. WS. All right. क्या है? Can you repeat the name and year? Name and year तो है sir, कोई नहीं. ये 2005 decision है, decided on 6/4/2005. Kailash versus Nannaku. Nanhaku. Chief Justice R.C. Lahoti, D.M. Dharmadhikari and P.K. Bala Subramanian. 6/4/2005 decision, Supreme Court. Kailash versus Nannaku. Clear? अच्छा जी. I hope you are clear about written statement. So let us proceed further and let us see this set off and counter claim. Now, set off and counter claim. So if you see particulars of set off to be given in WS, oh, very interesting. There are certain illustrations. Order 8, Rule 6. Order 8, Rule 6. Can you see Order 8, Rule 6 now? Order 8, Rule 6. Can you see this? It says when in a suit for recovery of money, so it should be suit for recovery of money. Now there can be short notes questions, so I'll tell you little bit about this. Set off, what is set off basically? Now let us read this set off. What is set off basically? Now first question is, what is this set off? So you write down, set off is reciprocal acquittal of debts. Reciprocal acquittal of debts. Set off is reciprocal acquittal of debts, and it is an action and it is an action. Oh, still no audio? Set off is reciprocal acquittal of debts and it is an action to recover an ascertained sum of money legally recoverable. Set off is reciprocal acquittal of debts and it is an action to recover an ascertained sum of money legally recoverable. Legally recoverable. Legally recoverable. Just write down because there can be short notes question also on this point. Legally recoverable. It is a kind of cross claim by defendant. It is a kind of cross claim by defendant It is a kind of cross claim by defendant. It is a kind of cross claim by defendant It is a kind of cross claim by defendant for which for which he might maintain an action for which he might maintain an action for which he might maintain an action against the plaintiff for which he might maintain an action against the plaintiff and which has the effect of and which has the effect of and which has the effect of extinguishing and which has the effect of extinguishing or which has the effect of extinguishing the plaintiff's claim. And which has the effect of extinguishing the plaintiff's claim. Then the para and then write down plaintiff's claim to an extent, either completely or partly, So if I have taken 100 rupees from you and you have 100 rupees claim, so entire set off. If I have taken 50 rupees from you and my claim is 100 rupees, so then 50 rupees will be set off. So it can be either plaintiff's claim either wholly or partly, both. Wholly or partly, both. In this sense, it is suit for recovery of money. In this sense, it is suit for recovery of money. Now, to claim set off, following conditions must be satisfied. To claim set off, following conditions must be satisfied. Following conditions must be satisfied. Following conditions must be satisfied. First, it should be suit for recovery of money. Second, the claim of defendant must be for a certain sum of money. Then third, such sum should be legally recoverable. Such sum should be legally recoverable. Legally recoverable. I think that you understand all this. Suit for recovery of money, there can be no other suit. If you want to recover money, then only claim of set off. The claim must be for ascertained sum of money. So it should not be only money, it should be ascertained. It should be fixed, clear, ascertained. 1,000 rupees or 2,000 rupees, it should be like this. then it should be legally recoverable. It should not be time barred. It should not be barred by limitation, not barred by law, not barred by law or limitation. Should be legally recoverable. Should be legally recoverable. It should not be barred by law or limitation. It should be legally recoverable. Then, number 4, it should not exceed pecuniary limits. It should not it should not exceed pecuniary limits. It should not exceed pecuniary jurisdiction of court. It should not exceed pecuniary jurisdiction of court. Should not exceed pecuniary jurisdiction of court. Number 5, both parties must be in same character. Must be in same character in set off. Must be in same character in suit as well as in claim of set off. As well as in claim of set off. So what is this same character? We'll try to understand. But illustrations given in order 8 rule 6 is not very happy one. It's complicated. So you should not worry much. And they have given these illustrations. And I have tried to explain them in my Bare Act as well. But I will clarify it little further. So you should not be stuck to these points, even if you do not understand few of them. It is not all in CPC. Certain people are stuck at certain points. You are required to understand CPC, not a particular point. So if you do not understand now 1 or 2 points, you should not worry much. If you reread, you will understand this. That is not at all an issue. You should not be very much concerned about that. And I did not understand this, I did not understand that. That should not be the idea. And then effect of set off is also written here. And then it says, the defendant may at the first hearing of suit, but not afterwards, unless permitted by the court, present a WS containing the particulars of the debt sought to be set off. So obviously, the claim of set off will be made in a written statement. This is where it should be made. The claim of set off will be made in written statement at the first hearing, but not afterwards, unless afterwards he has to seek permission of the court. Then what is the effect? The written statement shall have the same effect. It has the same effect as a plaint. It has the same effect as a plaint. So rule of pleading will apply in cross suit so as to enable the court to pronounce final judgment in respect of both of the original claim and the set-off. But this shall not affect the lien upon the amount decreed of any pleader in respect to the cost payable to him under the decree. The rule relating to written statement by defendant apply to written statement in answer to claim of. It has the same effect as a plaint. So, if the other party like plaintiff files uh, answer to claim of set off, then it will be considered then it will be considered then will be it will be considered defense. That is, it will be treated as it will be treated as WS, that is written statement. It will be treated as WS. It has the same effect. So set off has the same effect as plaint, because this is your claim. And the other party who files answer to this set off, answer to claim of set off, this will be treated as answer to set off will be treated as WS. Is this clear? Answer to set off will be treated as WS. That is what is written. So all the rules relating to plaint or WS will apply. You will have to pay the court fees. Now everything will apply similarly. If you claim set off, then you will have to file the court fees for claim of set off, because it is a kind of cross suit. For this purpose, you will have to file the separate suit. So we are allowing you to file the suit here itself, that is in form of set off. But you are not exempted from filing the court fees. You will be required to file the court fees. Only benefit which the parties will have is that there will be disposal of two claims in the same suit. So you will save the resources, or you will save the time of the court and your as well. So that is what is the advantage. That is what is the advantage. Is this clear? Is this clear? Is this all right? It should be, no, it should be filed as plaint. Set off is treated as a plaint. This is judgment on counterclaim. This is on counterclaim, my dear friend. This is beautiful. Counterclaim again. I will quote all this. Is this clear? Order 8, Rule 10. So this is not to be quoted here right now. Let us proceed further. Now, so you understand the following conditions which is required to be satisfied for filing of claim of. It will be claim only of money, which should be legally recoverable. It should not be barred by any kind of law or limitation. It should be a certain sum of money. It should be within the jurisdiction of court. Court fees has to be paid. It will be treated as a plaint in suit. So court fee will be applicable, and you will have to satisfy all the criteria of filing a plaint. That has to be done. When you will file this, you file it along with the written statement. If you do not file it with the written statement, then you are required to seek permission of the court to file it later on. It is always advisable to do it in advance. Now, then there are certain illustrations appended to this, but illustrations are not very happy illustrations, because they are complicated illustrations. Earl Richards had made this complicated illustrations. Which is not very beautiful, particularly illustration A and B. Now see, illustration C, I'm picking illustration C first. I'll come to A and B later. And not recoverable sum. So this is very simple. Amount not ascertained. The amount not being ascertained. Amount not ascertained. Illustration C, can you see? So no set off. This is very simple. If it is not ascertained, no. Illustration D. A sues B on a bill of exchange for rupees 5. B holds a judgment against A for rupees 1000. The two claims being both definite, particularly demands may be set up. Pecuniary demands may be set up. Both ascertained sum of money set off is applicable. Illustration D. Illustration E. A sues B for compensation on account of A sues B for compensation on account of trespass. B holds a promissory note for rupees 1000 from A and claims to set off that amount against any sum that A may recover. A may recover. B may do so for as soon as A recovers. So when he recovers, then this is done. So the moment recoverable amount is ascertained, recoverable amount is ascertained, the moment recoverable amount is ascertained, then claim of set off is allowed. 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 Illustration CD. When this will be ascertained, not right now. Now, F. A and B sue C for 1000 rupees. C cannot set up a debt due to him by A alone because the parties here. Now, A and B sue C for 1000. He cannot claim set off due to him by A alone because there is A versus, this is illustration F. On one hand, there is A and B. They file a suit against C. Question is, can C claim set off of money recoverable from A alone? Answer is no. Because here both are claimant, and here C is claimant only against A, not B. Not B. The parties are not same in that sense. Similarly, illustration G. A sues B and C both. B cannot set off. A debt due to him alone by A. Alone by A. B cannot set off a debt due to him alone by A. So this is B versus A. Here it is B and C versus A, or A versus B and C. B and C can claim set off against A. Illustration H. A owes partnership firm of B and C 1000 rupees. Now B dies. So after death of B, C is alone. In partnership, C is alone. So can C claim set off against A? Yes. B dies leaving C surviving. A sues C for a debt. C is alone now of rupees 1000 to 1500 in his separate character. C may set off the debt of rupees 1000. Yes, because C is alone now. Earlier it was combined, but now B has died. So C is the only person in the partnership firm. So can he claim set off? Yes. he can claim set off. So these are easier illustrations. Is this clear? All research has done all here, or whoever has drafted this. But now you see this illustration A and B. Nothing great here also, but I'll tell you how to understand this A and illustration A and B. I'll try to communicate, but this is not very happy about same character. So let us take illustration A also. See illustration A. I try to explain illustration A. It says A bequeaths rupees 2000 to B and appoints C as executor. So what is being said? A makes will, bequeath, in favor of whom? In favor of B. So A makes a will in favor of B. That is what is called bequeaths. वो उसको will कर देता है प्रॉपर्टी को क्या करता है will कर देता है A bequeaths rupees 2000 to B and appoints C as his executor and residuary legatee. So he appoints C as his executor. That is how he will execute the will. Executor, one who will execute it, executor, and residuary legatee. And residuary legatee. Residuary legatee means whatever is left in this property that will be available to him. That is what is residuary legatee. That is what is residuary legatee. Legatee, will is basically legation. The person who makes the will is called a legator, and the person in whose favor it is made, it is called legatee. Will is also called a legation. Person in whose favor will is made is legatee. The person making the will is legator. So residuary legatee means that he will give B whatever is there, and then whatever is left. Suppose he gives him 70% property. So 30% is left. So 30% will be available to residuary legatee. Residuary means rest. Rest is residual legatee. Is this clear? So A, suppose I am A and I have made a will in favor of B, you. And I make third person residuary legatee, let us say Mr. Vijay, that he will execute my will in your favor, and whatever is left, he will get it. This is what is the point. Is this clear? Is this all right? All right. Then it says further, B dies. B dies. And D takes out administration to B's effect. A should die first, but B dies. B dies. Now D is his administrator. D takes care of his property, B's property. All right. B dies and D takes out administration to B's effects. B's effects means B's property. B's property. Now this C pays 1000 rupees as surety for D. He pays 1000 rupees as surety for D. Then D sues C for the legacy. She cannot get set off against the legacy, for neither C nor D fills the same character with respect to legacy as they fill with respect to payment of 1000 rupees. So D takes out administration D takes out administration of B's property. You write down the illustration, understand it, very simple. D takes out administration of B's property. Now, in this transaction, when he takes out administration of B's property, C is surety. C is surety for what? C is surety. He pays 1,000 rupees as surety for D. C is surety of D. And pays 1,000 rupees. Clear? C is surety of D and pays 1,000 rupees in this transaction. All right. Now then D sues C for. Now D sues C for legacy. D किस चीज के लिए sue करता है? Sues for legacy. Against? Clear? Because C is A's representative and D is B's representative. So D sues on behalf of B against C, who is representative of A. Clear? D sues C for legacy. Now question is, now the amount which he has paid, C has paid as surety, can he adjust here this 1,000 rupees? The question is, can C adjust 1,000 rupees? Can C adjust 1,000 rupees paid by paid by D for him as surety? This is the question. Now, though it is made in long way, but you can understand that here the capacity of C is surety, and here the capacity is different, the character is different. The character is different. Here C is the representative of legator and D is representative of legatee. So he is in position of legatee and he is in position of legator. Because he is the representative of legator and he is the representative of legatee. And here C's capacity is surety. So surety and legator, is it same character? The answer is no. The answer is no. The answer is no. Legator and surety is not the same character. Legator and surety is not the same character. But why L. Richards has made so long illustration, I don't understand. In this illustration, C has dual character. That is, in legacy he is executor and in debt of 1,000 rupees he is surety. So he does not have the same character, so set off cannot apply. He does not have same character, so set off cannot apply. He has character of legator in one case and C has character of surety in another. So can set off apply? The answer is no. Set off cannot apply. In one capacity, he is acting as agent of legator. In another capacity, he is acting as surety. So these are two different characters. See, surety is basically a creditor, you know. Now, in this situation, if you see A and B situation, the first one which I have written, now this one, this situation. Basically, B is entitled to get something from A. So D is entitled to get something from C. In that character, you just understand. In that character, now, this is D who is entitled to get. So D is basically creditor in that capacity. And when C is surety, C is creditor. So in first case, D is creditor, in second case, C is creditor. So their situation is altogether different. In one situation, now C is ligator, and in another situation C is surety. So these are two different situations, two different characters. So in case of these two different characters, they cannot apply set off. C has आप देखते नहीं हो कि नहीं हो रहा है काम, तो आपको आके देखना चाहिए ना, बैठे हुए आराम से। क्लास में ध्यान नहीं है आपका, लग रहा है मुझे, हैं? देखते नहीं हो क्लास में कोई प्रॉब्लम हो रही, तुम्हारी जिम्मेदारी ना क्लास को ठीक करना। बच्चे बैठे हुए हैं क्लास में, तुम आराम से बैठे हुए वहाँ क्या कर रहे हो? पोस्ट कर रहे हो अभी? अभी तुम पोस्ट कर रहे हो रात में 7:30 बजे सुबह का पोस्ट? क्या कर, तुम क्लास में बैठे हो, देखो ना क्लास में कोई प्रॉब्लम हो रही तो कौन देखेगा? मैं बुलाऊंगा तब तुम्हें पता चलेगा, अदरवाइज तुम सब बैठे रहोगे, सोते रहोगे क्लास में। यार तुम तो रिस्पॉन्सिबल ही नहीं हो बिल्कुल। नहीं, इतनी प्रॉब्लम हो रही है लिखने में, बार बार प्रॉब्लम हो रही, तुम्हें दिख नहीं रहा नहीं? ये क्यों आ रहा है ये? जैसे ये बोर्ड भी डिफरेंट खुला हुआ है, पास बैठे हो लेकिन कुछ नहीं देख रहे हो। बंद तो कर देंगे, लेकिन आप क्या करो, मुझे तो ये क्लास चलाने आपकी जिम्मेदारी, मेरी जिम्मेदारी तो पढ़ाना है। इफ़ आई फेल इन टीचिंग देन आई विल बी रिस्पॉन्सिबल, अदरवाइज यू आर रिस्पॉन्सिबल। तुम कर क्या रहे हो भाई? यू आर सिटिंग आइडली, नो? सो रहे हो आराम से, में कोई मतलब नहीं है। कहाँ है? हाँ? Is this clear, my dear friends? पढ़ना इस illustration को, it's very interesting, you just read it. Now let us see illustration B. A dies intestate and in debt to B. A dies intestate, that is without making will. Intestate means without making will. And in debt to B. C takes out administration to age effect. Let us put it like this. A dies intestate, that is without making a will, in debt to B. All right? He takes out administration to age effect. He takes out administration to age effect. And B buys part of effects from C. Effect means property from C. B buys from C. Effect, property, I said. In a suit for purchase money by B against C, B buys part of effect from C. In a suit for purchase money by C, so C asks money. Obviously, you have purchased, B buys, so C will ask money. So C has filed a suit against B for purchase money. The letter cannot set off the debt against. So B has debt. B has debt from A to B. So B is entitled to get the loan. And C takes out administration on behalf of A. B buys part of effect from C. Is this clear? B buys part of effect from C. So C files suit for purchase money against B. He files a suit against B for purchase money. So he is entitled to get the money. Is this clear? Now B wants to claim set off because there is debt from A to B. So he is representative, so there is debt from A to B means there is debt from C to B in that sense. So now question arises here. The letter, can B claim set off? This is the question. Can B claim set off against C, against C for debt which was recoverable from A, that is C's master, let us say. Now here it says C fills two different characters. One as vendor to B, because he has sold something. So vendor to B. He is vendor to B because he has sold something. And other as representative of A. So these are two different characters. In one he sells the property, in another he is representative of A. So you can also write down that C has two different characters, one as vendor to B and another as representative of A. Another as representative of A. Another as representative of A. So these are the illustrations. These are the illustrations. 8 illustrations. 8 illustrations in this order. 8 rule 6. 8 illustrations. So this is what is the point on set off. ये set off है भाई, set off. Set off. अब एक छोटा सा क्वेश्चन लिख लो. Now, जरा सा पॉइंट लिख लो ये. When can one claim, at what stage you can claim क्वेश्चन फ्रेम कर रहा हूं. When one can claim the relief in form of set off. When one can claim a relief in form of when one can claim relief in form of set off. When one can claim relief in form of set off. When one can claim relief in form of set off. So write down answer. It can be claimed It can be claimed in first, written statement, second, it can be claimed even by way of amendment in pleading. It can be claimed even by way of amendment in pleading. Number three, even the court can allow one to claim set off. Even the court can allow one to claim set off by way of subsequent pleading. By way of subsequent pleading. Order 8, Rule 9. Order 8, Rule 9. Court can allow one to claim set off by way of subsequent pleading. So even after pleading has been filed, then you can file a subsequent pleading. Amendment in pleading, that is you amend the original pleading, and written a statement, that is original pleading. So you can claim it in original pleading in form of defense, then you can claim it by way of amendment, you can amend that pleading and you can do it, and subsequent pleading which you file as additional pleading. So there also you can claim this. Claiming of set off in WS is a matter of right, but later on it does not remain a matter of right. Later on it does not remain matter of right. Does not remain matter of right. Later on it does not remain matter of right. Earlier it is matter of right. So this is what is the difference. First it is matter of right, but later on it is not matter of right. In written statement you can claim it as a matter of right. But later on, if you want to claim it, then you will have to seek permission of the court. That is written also there. Is this clear? This is what is the point. Now, then there is another question. Can there be claim of set off? Can there be claim of set off beyond Order 8, Rule 6? Can there be claim of set off beyond Order 8, Rule 6? You write down the question, I will explain it, don't worry. Kirtiman. All right. Can there be claim of set off? Can there be claim of set off beyond Order 8, Rule 6? Write down on this point, Order 8, Rule 6 is not exhaustive. Order 8, Rule 6 is not exhaustive. Order 8, Rule 6 is not exhaustive. It only talks of legal set off. It only talks of legal set off. But there can be claim of equitable set off as well. But there can be claim of equitable set off as well. But there can be claim of equitable set off as well. This concept of equitable set off, is contained in, this claim of equitable set off is contained in Order 20, Rule 19, Order 20, Rule 19, Sub-Rule 3. Order 20, Rule 19, Sub-Rule 3. equitable set-off. Even in equitable setup, you are required to pay the court fees. There has been some confusion in mind of certain people that in legal setup there will be payment of court fee. In equitable setup there will be no payment of court fees. But this is not the law. Law is very clear on the point. In both cases, you are claiming now. You are claiming money. So if you are making a claim for which a suit should be filed, and I am allowing you to file this suit, in this case cross suit, in form of set-off, so are you not required to pay the court fees? You are required to pay the court fees. So it can be even for unascertained sum of money. It can be even for unascertained sum of money. Unascertained sum of money. It can be even for unascertained sum of money. Now then the next question, what is the difference between legal set-off and equitable set-off? Question is, what is the difference between legal set-off what is the difference between legal set-off and equitable set-off? Legal set-off and equitable set-off. So difference here it is now in legal. And equitable. Ascertained sum, unascertained. It can be unascertained. Unascertained sum of money. It is your matter of right. It is discretion of court, not matter of right. Not matter of right, because it does not fulfill that criteria. Not necessary to be in same transaction. It is legally recoverable. Not legally recoverable. It may be time barred. Here it is order. Here it is order 8, rule 6. Here it is order 20, rule 19, sub rule 3. In both cases, court fees is payable. Both cases, court fees payable. Court fees payable. There is judgment to this effect also, but that is not necessary to be quoted here. In both cases, court fees is payable. In both cases, court fees payable. In both cases, court fees payable. Now there is a case also, Jitendra Kumar Khan versus Peerless General Finance and Investment. Jitendra Kumar Khan versus Peerless General Finance and Investment. In legal set-off, it is a matter of right of claimant, whereas in equitable set-off, it is discretion of court. It is discretion of court. 2013 judgment. I do not have proper citation, so don't worry. This is what I think concludes this set off. Now we'll be discussing counterclaim, not today. We'll discuss it in next class. But you have a question, Kirtiman Dvivedi, that could you please explain this illustration 1 in Hindi? I will do it, sir. तो मैं यदि आपको हिंदी भाषा में बताऊं तो आदेश संख्या 8 का नियम संख्या 6 का पहला दृष्टांत है ये, जिसमें कहा गया है कि ए ने अपनी संपत्ति का विल बनाया है बी के फेवर में 2000 रुपये का, और सी को उसका एग्जीक्यूटर और रेजिडरी लेगेटी अपॉइंट कर दिया। यानी 2000 रुपये का प्रॉपर्टी तो दे दिया बी को, उसकी प्रॉपर्टी होगी 5000 की मान लीजिए, तो बाकी जो प्रॉपर्टी होगी वो सी के पास जाएगी, और सी ही एग्जीक्यूटर है, सी को ही विल को एग्जीक्यूट कराना है और सी के पास बाकी जाएगा, उसी को रेजिडरी लिगेटी कहते हैं। मैं हिंदी भाषा में बोल रहा हूँ। भाई एग्जाम्पल इक्विटेबल सेटअप का यही कहना है, सर्टेन सम ऑफ मनी है तो इक्विटेबल में आ जाएगा। हर चीज का एग्जाम्पल नहीं बनाने लगो, ध्यान से सुनो भी पहले मेरी बात। मैं बता रहा हूँ इलस्ट्रेशन 1, फिर बात करेंगे सवाल पर। बी डाइज, बी की मृत्यु पहले हो जाती है, एंड डी टेक्स आउट एडमिनिस्ट्रेशन टू बीज इफेक्ट्स, और डी उसके संपत्ति का, बी की संपत्ति का जिसको मिला था विल में प्रॉपर्टी, उसकी संपत्ति का वो एडमिनिस्ट्रेशन निकालता है। डी ने उस संदर्भ में डी को 1000 रुपये दिए श्योरिटी, डी के बिहाफ पर उसने 1000 रुपये श्योरिटी के दे दिए। अब डी कहता है कि जो 1000 रुपये तुमने श्योरिटी के लिए मुझे दिए उसको तुम इस विल में एडजस्ट कर दो। भाई 2000 रुपये मुझे मिलने ही थे बी के बिहाफ पर, तो 1000 रुपये उसमें एडजस्ट कर दो। तो प्रश्न यही है कि क्या जो बी को 2000 रुपये ए से मिलने थे, यानी अब वो डी को मिलेंगे क्योंकि डी है उसके बिहाफ पर, बी के बिहाफ पर, बी का तो डेथ हो गया, और सी ने श्योरिटी के फॉर्म में डी के बिहाफ पर 1000 रुपये दिए थे, तो कैन दैट 1000 रुपीज ऑफ सी गिवन एज श्योरिटी, जो श्योरिटी के तौर पे सी ने दिया 1000 रुपये, क्या वो डी जो है 2000 रुपये में एडजस्ट करा सकता है? यही सवाल है, क्या ये सी एडजस्ट करा सकता है, यही सवाल है। तो न्यायालय ने कहा कि दोनों की कैरेक्टर डिफरेंट है, एक में सी जो है वो विल का एग्जीक्यूटर है, रिप्रेजेंटेटिव है वो ए का, और दूसरे में वो श्योरिटी है डी का। तो रिप्रेजेंटेटिव ऑफ ए एंड श्योरिटी फॉर डी, दीज आर टू डिफरेंट कैरेक्टर्स, so he doesn't have same character, so we are not going to adjust this set off, we are not going to adjust this set off। तो बुलाना जरा विवेक को। और कोई सवाल है तो बताइए, हम लोग कल काउंटर क्लेम की चर्चा करेंगे, और आपसे मैंने कहा है कि नाउ यू मस्ट स्टार्ट सॉल्विंग द क्वेश्चन, एंड यू मस्ट सी दिस ऑर्डर 1 to 7 questions, apart from this section 9 and section 15 to 20 questions. Please drop all those questions in WhatsApp group so that I will be able to respond to your questions well. Is this clear? So you will drop the question, and if you have got anything new, please let me know, or if there is any new question in your mind, please let me know. I will respond to each and every question. Is this all right? आपके पास 30 days for submission of WS from the date of summons issued or received। ये देखो ना, लिखा है डेट ऑफ सर्विस। तुम लोग भाषा पढ़ना सीखो, केवल सवाल ही पूछना। लिखा है यहाँ पर फ्रॉम द डेट ऑफ सर्विस ऑफ समन, तो सर्विस कब होगी? जब तुम्हें मिलेगा कि उसके पहले ही सर्विस हो जाएगा। हाँ, तो रिसीव्ड ही होगा ना। एट व्हाट स्टेज वी कैन कन्फर दैट राइट क्लेमिंग सेट ऑफ पास्ट अवे, क्या है सवाल? एट व्हाट स्टेज वी कैन कन्फर दैट राइट इज क्लेमिंग सेट ऑफ पास्ट अवे। नो आरती, आई एम नॉट क्लियर अबाउट दिस लैंग्वेज, ये मुझे समझ में नहीं आया क्या। एट व्हाट स्टेज वी कैन कन्फर दैट राइट इज क्लेमिंग सेट ऑफ पास्ट अवे। I think that you are trying to ask the question when I cannot claim set off. I have already told you the stage of claiming set off. You have written this in class. Either I can claim set off in filing of WS, or I can claim set off by way of amendment of pleading, or I can claim set off by filing of additional pleading. Order 8 Rule 9 and Order 8 Rule 1 After that, you do not have right to claim set off. It will be discretion of court. Court may allow or court may not allow. It is written in Order 8, Rule 6, Sub-Rule 2, I think. Now, it is written in Sub-Rule 1 itself, but not afterwards. It is written in Order 8, Order 8, Rule 6, Sub-Rule 1. ये सब और कोई सवाल है तो बताइए कृपया। जो पॉइंट है ना, इसको अभी से मेटल में डालना हम लोग शुरू करें। देखो, इसमें बड़ी इंपॉर्टेंट पॉइंट्स पढ़ो। दिस इज ऑन काउंटर क्लेम, पढ़ो इसको। इट शुड बी। एनी अदर क्वेश्चन प्लीज? दिस पॉइंट हमारे बैरक में भी जाएगा, मेटल में भी जाएगा। यू कैन ऐड दिस ऑल्सो, बैरक, मटीरियल बोथ, एंड फ्रेम क्वेश्चंस ऑन दीज केसेस। लेकिन इसके लिए तुमको थोड़ा पढ़ना पड़ेगा ध्यान से। Any other question? Please explain condition of same character in illustration E. Illustration E तो बहुत आसान था। Illustration E तो बड़ा आसान था। भी बताते। सेम कैरेक्टर की बात तो इलस्ट्रेशन ई में है ही नहीं कुछ भी। ये तो सिंपल है। प्रोमिसरी नोट है 1000 रुपए का। A sues B for compensation account. B holds a promissory note. So it says that A may recover in the suit. So the sum recovered, sum which will be recovered. So suppose sum is recovered 2000. So you can adjust 1000 rupees against that. It is about definite pecuniary demand, not about character. Ujjwal. It is not about character, it is about pecuniary demand. Ascertained sum of money per hai, ascertained sum of money. एंड इफ यू हैव नॉट अंडरस्टूड एनीथिंग तो लेक्चर को भी सुन सकते हो। मैंने इलस्ट्रेशन ए और बी बहुत अच्छे से समझाने का प्रयास किया है। आई ट्राइड माई लेवल बेस्ट टू मेक यू क्लियर ऑन द पॉइंट। अब देखो, ये एक 2021 का भी जजमेंट है, चलते चलते आपको बता देते हैं, भी डालना। दिस इज 2021 जजमेंट, जस्टिस हेमंत गुप्ता वर्सेस रामा सुब्रमण्यन, सरोज सिंह वर्सेस चरण सिंह। versus Charan Singh. This is a decision of 8 October 2021. Justice Hemant Gupta and B. Rama Subramanian. This is Supreme Court decision. Supreme Court decision on 8 October 2021. Now, in this case, Supreme Court said that the period of 90 days for filing WS under Order 8 Rule 1 is directory. Period of 90 days for filing WS is directory and not mandatory. That has been said in Kailash versus Nanku also, and that has been said in Salem 2 also. Justice Hemant Gupta and V. Rama Subramaniam held that provision of Order 8 Rule 1 are mandatory in commercial courts under the Commercial Courts Act, are mandatory there. But it is mandatory. I have already said this, 120 days is the maximum limit, and it has been said, court shall not. There is prescriptive language. And the defendant will forfeit his right. That is the language in commercial courts. Provision of Order 8, but it is mandatory in commercial courts. That is 120 days. Is this clear? Mandatory in commercial courts. Is this all right, my dear friend? अब तुम्हें ये बताओ कि समझ में आया कि नहीं written statement and this set off. Did you understand this or not? Let me know. And if you have any question, query, please drop in WhatsApp group, not individually. Individually, it will not be possible to answer your question. चलें फिर, ओके, बाय बाय। समझ गए ना।